So far we have seen that the confusion is created by the use of these various different influences from different languages and from different periods of the development of legal English. The next few segments I want to talk about some rules of plain English, and I'm going to firstly give you some example of poor drafting, poor legal drafting, and then we're going to talk about how we can address this problem and be concise and write more plainly. Consider, for example, the following clause from a will, a testament. I, Jane Edwards, from Bendigo, do hereby publish, make and declare this as and for my last will and testament, hereby revoking all wills and codicils thereto heretofore by me made. Let me first ask you, is there a difference between a will and a testament? Not quite, not really. And also, how do we know that this is Jane Edwards's last will? Perhaps she had gone to a different, she went to a different lawyer after preparing this will later on, and then there was another last will and testament. We just don't know whether she had changed her mind or not. What about this phrase that she hereby makes, publishes and declares this as her last will? Makes, publishes and declares. Do we need all of these words? Probably not. And as and for also appear to be redundant in that phrase. Also, to me, the words such as thereto, heretofore, by me made sounds rather archaic. And also, would you say by me made? Or rather, made by me? You see, this is another example where the, in this case, testator has, or the drafter rather, has swapped the words around a little bit so that it sounds a little bit strange as well. And what is the plain English redraft of this will? Well, Professor Tiersma, a leading legal linguist, legal expert in legal linguistics, says you can simply summarize this will, or this clause in the will, as follows. I, Jane Edwards, declare this to be my will and revoke any previous wills. Full stop. It's much shorter, much more elegant. But the question arises, will the client be happy to pay for something as simple as that? And indeed, Professor Tiersma suggests that lawyers tend to use this obscure terminology partly in order to protect the monopoly on their legal services. A similar argument was earlier also advanced by German sociologist Max Weber, who observed the inner workings of the Inns of Court in London and the practices of barristers who kept their knowledge of the procedure tightly wrapped so that they would be in control of court procedures. And he basically says any simplification of the legal language and the rules of legal procedure threatens the material interests of the practitioners. And one of the results of this practice is this complex legal terminology and also quite complex rules of procedure.